Go ahead, Mr. Wonderful.
In cause number 2021 DCV 0387 Felipe Jesus Luna et al. Versus Edwards Homes of El Paso LLC et al. Announcement of council, please.
Your Honor, Jason Chapman on behalf of the plaintiffs.
Morning, Judge Jim Martinez and Hala Abdul Jaber for the defendant.
Good morning. We're here on a motion to reinstate. It looks like this was dismissed back in May. I actually had to go back into the Zoom hearings because I feel like I hadn't seen you all in a long time. So what happened? I mean, I see the dismissal back in May of last year.
Right, Judge. There's an arbitration clause, and Mr. Martinez early on had filed a motion to compel the arbitration. I agreed to it. An order was entered dismissing the case without prejudice until the arbitration was completed. We originally had an agreement, and Judge Villa was going to hear our case. And Jim, chime in if I don't have the exact timeline correct, but Judge Villa recused himself, and then at that point, the parties went back and forth on trying to agree on a local arbitrator, and were unable to.
That's where Mr. Chapman, that's where the last hearing I saw, that's where we were. We were kind of at not either, I don't know if Mr. Martinez, I think there was some comment that Mr. Martinez may not have had authority from his clients to agree to a certain type of mediator. I didn't quite see how we got to the dismissal, and we didn't really have a follow-up. Was there any movement?
Well, Judge,
go ahead, Jason.
This case, I think, and Mr. Martinez, correct me if I'm wrong, kept on popping up on your docket, although the order that was submitted, and I think and agreed to by both parties, said it would be dismissed without prejudice pending, the completion of the arbitration. And so finally, I think Mr. Martinez informed the court that this thing has been dismissed, and that's why you haven't heard from us for a long time. Originally, I think this arbitration was set in February of this year with Judge Villa, and he recused himself. So since that time, we've been scrambling to back and forth on potential arbitrators, and there hasn't been an agreement. The other issue just kind of with me is kind of client issues, and I'm stuck without a forum. If I need to get out of the case, I have no place to go. And that's where I left it with Mr. Martinez, and that's why I told him the reason for filing the motion to reinstate.
Judge, may I respond?
You may.
Judge, procedurally, I think Jason has it almost correct. The court initially dismissed this case over 2 years ago. It was actually March of 2021. And if you read the order, it says dismissed without prejudice, dismissed. And I'm not sure what happened in the district clerk's office, but they didn't get the message. So they left it on your docket, which is why I think you kept having recurring hearings. And finally, sometime last year, I'm not sure what you did, but evidently you cleared your throat, and somehow the district clerk got the message and finally said, oh, it's been dismissed. Well, then we'll take it off your docket. So it took a year and 2 months, but the original dismissal was finally effected last year in May. And Judge, I can tell you where we've been. This is the one part I disagree with Jason, and I realize he may be in a difficult spot, but there is a solution right in front of him. And he's correct. We were with Judge Villa. Judge Villa developed a conflict and therefore recused himself, and I have no complaints about that. But after we lost Villa, I informed Mr. Chapman. I said, look, the arbitration agreement says you got to do it pursuant to the rules of the AAA. That's what it says. And the rules of the AAA, I mean, they're the AAA's rules. They're not dumb, right? They say, well, if you want to initiate an arbitration, you come here to the AAA. Mm-hmm. And so I told Mr. Chapman repeatedly, Jason, go file with the AAA. We consent, we'll arbitrate in front of the AAA, but I'm not going to pay the arbitration fee. You're initiating the arbitration. You need to do that. Go initiate the arbitration with the AAA, and I'll pay my part when I respond. We'll do that. So my point is, Judge, I just don't think there's a need to reinstate it. He does have a remedy. His clients have a remedy. All you have to do is follow the arbitration agreement and file institute the arbitration proceeding with the AAA, and we'll respond, and they'll do their usual scheduling stuff, and we'll get a hearing date. Short of that, Judge, I just don't think, I mean, it's been 2 years. I don't think there's any reason for the court to try to exercise its jurisdiction over a case it dismissed over 2 years ago, unless and until there's an arbitration award that needs to be reduced to judgment. There's no impediment to arbitration. We're happy to go. Mr. Chapman just needs to do the legwork to get that done.
Mr. Chapman?
Yeah, my response to that, and I've got the arbitration clause right here. It just says it would be a binding arbitration by a single arbitrator to occur in El Paso, Texas, in accordance with the commercial rules of the AAA. We've done arbitrations pursuant to those rules with a local arbitrator or a single arbitrator. And I think that's kind of the dispute. My client is opposed to AAA. That's part of the problem. And if I need relief from the court to possibly get out, I don't have a forum to do it. Does that make sense? I would prefer, if I need to get out, and that I have an order getting me out, as opposed to where I am right now, where I'm not in a forum. And I understand Mr. Martinez's argument, but in order to get out, I'd have to convince my client to pay that fee. And then I would have to have that arbitrator grant a withdrawal.
Judge, the only thing I would say in response is Mr. Chapman has made it sound like there's a conflict between using the AAA rules and having a single arbitrator in El Paso. There isn't. I've had plenty of arbitrations that the AAA administered, where they appointed one arbitrator, and our arbitrator came out to El Paso, and we had all the proceedings here in El Paso. I think it's the simplest analysis is the AAA's rules that the parties agreed to apply say you file with the AAA.
Mm-hmm.
That's that simple.
What?
Mr. Chapman, do you have anything else?
Yeah, the only other comment is if you're going to order it to AAA, which is fine, I would ask that at least the court would take jurisdiction in case that causes a huge conflict with my client and I need to withdraw. Because otherwise.
Yeah, I don't like putting lawyers in a jam. Even lawyers I don't like, and Mr. Chapman and I actually get along just fine. But if the sole issue was a withdrawal, I don't object to the court, exercising jurisdiction solely for the purpose of granting a motion to withdraw, so long as we're still going to arbitrate with the AAA if they proceed pro se or if they get another lawyer or whatever.
Yeah, I'm not inclined to reinstate it, period. And so the motion to reinstate is denied. That's all I have. Sorry, Mr. Chapman.
Okay, thank you, Judge.
All right, take care.
Judge, thank you.
Have a good day.
Yes, ma'am.
Okay, do we have everybody here on, let me get my binders out of the way. On the next case, the motion to compel.
I believe so, Judge.
All right.
Yes, I think so, Your Honor. This is Matt Greenberg. I'm the movant for the Alonso family.
Correct. Oh, and there's Mr. Snyder. I didn't know if we were going to have, I was starting to think we were going to have all different faces today, but no, Mr. Greenberg, Mr. Forbes, I see Mr. Snyder, just Mr. Morris and Mr. Aguilar. I mean, Miss Aguilar are different. Let's get started.
In cause number 2021, DCV 3028, Rosa Maria Saucedo de Alonso et al. Versus Fifth Floor Freight LLC et al. Announcement of council, please.
Matt Greenberg from Zell and Associates for the Alonso family.
Norman Snyder on behalf of Fifth Floor Freight LLC.
Kenny Morris on behalf of Claudia Guzman.
Kristen Aguilar on behalf of defendant Detmar.
Stuart Forbes on behalf of the interveners, Edith Erickson and Daniel Huerta.
All right, we're here on a motion to compel. Let me just go through some of these entries to make sure I have. These are the motions that were filed on April 24th, correct?
Yes, Your Honor.
Okay. All right, Mr. Greenberg, go ahead.
I have two motions pending before your honor. The first is a motion to compel a privilege log. The second is motion to compel data, video, photographs related to electronic data that is stored I think it's stored in the cloud through a program called Sincera. I'll note that I didn't see a response to either one of the motions. So if there was a response, I haven't read it yet. I'll just make that statement at the outset. But I'll take the privilege log issue first, if that's fine.
Yes, sir.
My understanding of when I read the Lumberton case that I cited along with Rule 193, if there are basically three kinds of general privileges people think about. They think about attorney-client communications, they think about attorney work product, then they think about party work product. Party work product has to go on a privilege log. Attorney work product does not. Attorney-client communications do not. But the third section, party work product, does. Party work product is what the case law calls core work product. It's the party's work product, not the attorney's work product. Fifth floor's responses indicate that they are withholding documents protected by core work product, which is party work product. If that's true, it has to go on the privilege log, and the Lumberton case makes that very clear. There were supplemental productions done, I think maybe within an hour ago, where Fifth Floor reiterated that they are withholding core work product. If that's the case, I've requested a privilege log. None has been provided. I've been told none will be provided, and therefore I'm asking the court to compel a privilege log for the core work product documents indicated in Fifth Floor's responses to my request for production.
I respond, Your Honor?
Yes, Mr. Snyder.
All right. Your Honor, this morning we filed supplemental responses to the plaintiff's first request for production. And in our supplemental response, we discreetly set out those document requests to which we had previously objected based upon the work product privilege and the attorney-client privilege. All right. There were, if I've counted correctly, about 15 instances in which we asserted both the attorney-client privilege and the work product privilege. This morning, and I thought we had done this previously, but perhaps we didn't. But in any event, to each of those document requests in our supplemental response, we have said, for the most part, that no responsive documents, if there are any, have been withheld other than documents that are protected by the attorney-client privilege and core work product privilege. Now, core work product is work product that includes the mental thoughts, processes, impressions, and conclusions of a party's attorney. And I will disagree with Mr. Greenberg. I believe that the rules absolutely protect documents that contain those. But we have not withheld any other documents based upon the work product privilege where my client developed any information concerning the investigation of the accident, the facts and circumstances of the accident, or anything like that. So I do not believe that a privilege log is needed for documents that, if there are any, that have been withheld based upon the attorney-client privilege or the core work product privilege, that being documents that contains the lawyer's thoughts, mental impressions, and conclusions.
Yeah, I'm not asking for a privilege log that contains attorney work product. What I'm asking for is a privilege log that contains party work product. If the party anticipated litigation and took steps communications, investigations, held meetings, and there are documents related to that that weren't done at the behest of an attorney, that goes on the privilege log. So to the extent those exist, I think that those go on the privilege log. I'm not asking for attorney work product on a privilege log.
And I understand, Mr. Greenberg, and I don't think that I disagree with you about that, but what I'm telling you is, and maybe I didn't articulate it very well, there are no such documents that exist in this case of which I'm aware of, and I have gone back and reviewed pretty carefully every document, every electronic document that appears in my file.
And the only response to your honor is, if that's true, then an objection to privilege is not warranted. It's inappropriate to object to privilege because you don't have to object to, if it's attorney work product or attorney-client communication, you don't have to insert an objection. When you insert an objection to a request, what you're indicating is that there's party work product. Otherwise, you just don't do it because nobody ever anticipates you ever getting those documents.
All right. Well, if I need to further supplement my client's response, I'll do that by stating that any assertion of privilege based upon party work product is withdrawn, but I am not withdrawing assertions of privilege based upon the attorney-client privilege or the core work product privilege.
Mr. Greenberg, Mr. Snyder mentioned there were supplemental responses this morning. Have you seen those?
I have, and I think the problem is just when you indicate that you're withholding documents, you usually only do that when you are withholding documents. In your typical response to an RFP, you don't indicate I'm withholding attorney-client communications from it, right? Because that's just that's de rigueur. You just do it anyway, right? So the fact that it articulates that they are withholding core work product documents, I wasn't sure what that means. If that means that there's only documents that have attorney's fingerprints on it and there's nothing else, that's fine. It just is not really clear from this. Plus, I only got it 20 minutes.
Well,
but that's fine. That's fine. I mean, if you supplement.
So I would, just so that we have this clarified and we have an understanding between the two of you that what that response really means. So Mr. Snyder, if you could re-amend that response to reflect what was discussed here today. Mr. Greenberg, I will leave that matter open. Well, let me see if you have anything else, but I'll leave that open and for you to request the court address it again in the event what you receive is not satisfactory.
Okay.
I will do that. Let me just state for the record that I know typically in accidents like this, for example, an insurance company may send out an insurance adjuster or a third-party claims adjuster out to an accident scene to investigate and do all that kind of work. That was not done in this particular case because the facts are that my client, within 24 hours, hired an attorney in Midland, Texas, Blue Hyatt, to basically do those sorts of things. So I'm happy to amend, resupplement those responses, and hopefully articulate that better and make it more clear. And then if Mr. Greenberg is still not satisfied, I'm happy to revisit that with you, Judge Perez.
Okay, sounds good. Mr. Greenberg, anything else on that one?
No, Your Honor.
Okay, thank you. Let's move on to the next one.
The next one, Your Honor, is my motion to compel the Samsara data. I mean, I'll be brief. We've been given by Fifth Floor a single snapshot. It's contained in my motion, but it looks pretty much like this. It's a dark road. What it is it's a snapshot, a screenshot of an electronic dashboard from a cloud-based platform that we see in a lot of these cases with additional information on it. The information is very clearly, if you take a look at it, that there's additional information, photographs, videos, GPS data that can be retrieved from the platform that was not retrieved from the platform. All I have is a single screenshot. Of particular note, as I point out in my motion at the bottom right of the screenshot, is what's obviously a button that says retrieve video.
Yes,
I'd
I
like the video. Click the button and give it to me because it's relevant to this crash. Additional information that can be gleaned from this, if you look at the top, it's clear that there's only the 422 little screenshot is selected along the top.
Mhm.
There's 417, 412, 407. There's all these other ones that are kind of they actually look like video versus pictures. There's GPS data on the right. There's a little toggle down at the top right where you can, it's a drop down menu where you can click all videos and images. All that's relevant data. It's responsive to 3 RFPs at a minimum. Should also be in initial disclosures, and I would like this information. I'll just tell you, both Mr. Morris and Mr. Pena and my office, we've tried to get this information from Samsara directly. Their response, they've objected to mine. I'm pretty sure they objected to Lasheen's office as well. Their response is get it from 5th floor. They're the ones that have access to it when we're not going to do it for you. So I got to have it. It seems relevant. It seems easily accessible. I don't know why I don't have it.
So is this screenshot, that's the only thing that was produced, this document
Yes, from Samsara. Yes,
from Samsung? Okay,
from this online portal. And we see this all the time. We see it like they call it Lytics and all these other kind of cloud-based systems. It contains a tremendous amount of relevant information and data. And yet we have one single screenshot without the rest of the production.
okay.
Can I respond, Your Honor?
Yes, sir.
Right. Your Honor, the response is that my client has produced everything that they have in their possession, custody, or control that quote unquote concerns Samsara data. I wish we had the other data to which Mr. Greenberg is referring and suggests exists. I don't know whether it exists or not. All that I can tell you is I have gone back to my client and asked them if there is anything else other than the Samsara data that we produced. And it was among 500 pages of documents that we produced. They don't have it. My client, I actually asked them to go to Samsara and see if they could obtain it directly from Samsara. And the answer, as I'm told, was that Samsara no longer has it. So I don't know why Samsara has refused to respond or produce anything to Mr. Greenberg or Mr. Morris or anybody else, because if there is such data that exists and still exists, it's relevant data. And I would like to have it as much as Mr. Greenberg, Mr. Morris, or anybody else. And I wish I did have it, but I don't have it.
I'm sorry, that just defies logic and belief, because how'd they get this?
Well, I think I think one explanation may be is that, and as I understand this technology, and I don't pretend to be the expert about it, either Samsara, some of the other devices that are out there that do similar things like Geotab and everything. But my understanding is that Samsara has devices that are placed in these tractors or somewhere on these tractors that periodically records data, including images like the one that Mr. Greenberg showed you. My client had just left a location where he had picked up, Mr. Uresti had picked up a sandbox and had just gotten back out onto the highway when this accident occurred. So there's a couple of things that could be possible here. Number one, if this records data, images, and so forth periodically, it may not have recorded data or images immediately before this accident occurred, particularly given the fact that Mr. Uresti had just left this sand plant where he picked up this sandbox.
Yeah, I mean, I'll just tell you, Your Honor, that's not how these work. They work backwards from an incident. So if there's a crash, for example, they work backwards and they're constantly recording and it saves upon triggering events. That's how it works. A triggering event can be a crash and it works backwards because I do this all the time. And just to that's fine. He can try to explain it. It's clear that they got one image and produced it. It's also very clear from this image, other images exist. If they can get this one, they can get the others in the video. What it seems like the answer is from Mr. Snyder is they haven't made the attempt to do it because he said he doesn't know if they can do it or not. Well, I've sent the request for production. It's their obligation to try. I do not believe that they can produce one page from this dashboard and can't get this other information up here. So I'm asking the court, regardless of what Mr. Snyder has said, to enter the order compelling them to at least go get this information that seems readily available.
Well, if it's not in our possession, custody, or control, Your Honor, and it's not, I don't know how the court can compel me to produce something that is actually in the possession, custody, and control of a third party, Samsara. I'll ask the client to go back to Samsara. I'll work with Mr. Greenberg and Mr. Morris in any effort that they wish to continue to undertake to try and get this directly from Samsara. I'm happy to do that. But if my client doesn't have it, they just simply don't have it.
I'm sorry. One last thing, then I'm going to stop talking, Your Honor, is how did they get this? It's very clear from this document that what is selected is the 422 screenshot. And then that's what's clicked on and produced. Somebody clicked on it and only produced this specific one. That person just needs to click on the other ones.
Yeah. All right. Anything else, Mr. Snyder?
No, Your Honor.
Okay. So the motion to compel with respect to the Samsara data is granted. What I want to maybe get a better understanding from you all who have dealt with this more often is what is a realistic timetable. I mean, I want to say 30 days. And so, I'm just not hearing, I hear what you were saying, Mr. Snyder. I'm not sure that was in the responses to Mr. Greenberg or not, but obviously we're hearing that now. I still think I tend to agree with plaintiff here that it does appear that there should be a whole bunch of information attached to that screenshot. And so the motion is granted. Have 30 days. We are going to reconvene on the motion to compel the Samsara data. I'm not anticipating having anything with respect to the privilege log, but Mr. Greenberg, I'll rely on you to let the court know if we need to come back on something in 30 days there as well.
Yes, Your Honor.
All right.
Do you have a date when we're going to reconvene concerning the Samsara data?
Sure. Let's go with June 21st at 10:30 a.m.
Yes, Your Honor.
That gets us right around 30 days. Okay. Yeah, let's do that. All righty. Thank you very much for your time. Is there anything else for today?
No, Your Honor.
I
All right.
believe so.
Y'all are excused. Take care.
Thank you.
Thank you.
Thank you, Your Honor.
All right. Yeah, I did notice that, Anita. I saw and I heard doorbells and whatnot. So thank you. All right. Who's next?
Page 5, top of page 5, Judge.
Mhm.
In cause number 2022 DCV 3622, Mary Gonzalez versus Jovencio Pacheco and Rebecca Pacheco. Announcement of council, please.
Enrique Lopez, I'm sorry.
Good morning, Your Honor. Nassim Saloom for the plaintiff, Mary Gonzalez.
Enrique Lopez for Juvencio Pacheco, defendants and movements on this motion.
Okay, I know we were just here. I believe is that your client, Mr. Lopez, that's
Yes, Your Honor.
to connect. Okay, bear with me, please. All right. Did he check in? I mean, did he log in? No. Mr. Lopez, are you okay to proceed without? Oh, no, there he goes.
Yes, Your Honor.
He's connected.
Yes, Your Honor.
Okay, so we have I guess, a reset or continuation of the temporary injunction hearing today. Bear with me, counsel. Where are we on this one? I know we denied the
Discovery dispute.
mhm,
We denied
yes, sir.
that. And
So
but now we're here
what's
on
going on today?
Yes, Your Honor, we have the continuation on our motion, defendant's motion for temporary injunction and to require payments to be deposited with the court or directly to my client.
Mhm.
This is stemming from a lease agreement that was entered back in January of 2020 for 2 years. That lease agreement had the option of the plaintiff, in this case, Mary Gonzalez, to purchase that property within those 2 years. But she had to continue paying the rent of $1,500 per month. It's a lease agreement with an option to purchase. The plaintiff, Mary Gonzalez, did not purchase the property within those 2 years. But she continued being a tenant on a month-to-month on a $1,500 per month. In February, there was another attempt by the plaintiff to try to purchase the property. They entered into a second contract for the plaintiff to purchase the property, and that was signed by the plaintiff, Ms. Mary Gonzalez, on February 9th of 2022. The contract itself requested that the plaintiff, Mary Gonzalez, who's the tenant, deposit $10,000 as earnest money on that contract. That plaintiff never made that $10,000 deposit. So that contract essentially was breached by the plaintiff. And now we try to file a forcible detainer in justice of the peace, saying that they hadn't paid the rent because since April of 2022, they stopped paying on the rent, yet they're still occupying Mr. Pacheco, the defendant's property. We try to do a forcible detainer. Ms. Mary Gonzalez files a lawsuit stating that there's an issue regarding a title or ownership. Obviously, the justice of the peace could not proceed with the eviction. So here we are in your court. However, since April of 2022 to the present, Mary Gonzalez, the plaintiff in this case, has not paid any of the rent. And we're $19,500 just in rent payment, not including any late fees. And so she's occupying the property, not paying anything, claiming that there's a breach of contract, maybe suing for specific performance, but that is issue to be determined by your honor or a jury down the road. And that's fine. She can continue with that claim. However, she needs to move out or pay us the monies, the $19,000 that she owes, and continue depositing that money, whether directly to Mr. Pacheco, who's certainly entitled to that money, that's his property, or in the event the court feels it more appropriate, to be deposited into the registry of the court. So that's our relief requested, that she continue making the payments and pay up what she owes, $19,500 immediately, or move on.
Okay, Mr. Solomon.
Yes, Your Honor. May it please the court. I'd like to clear some things Mr. Lopez was alluded to. So this was a commercial lease agreement, and it did contain an offer to purchase. What our position is, an executory contract, a lease with an option to purchase. Upon the inception of the lease, Ms. Gonzalez paid a $10,000 deposit per the terms of the contract of the lease to own.
Let me stop you right there. Mr. Lopez, did I hear you say that that was not paid?
No, the first 10,000 was paid.
Was paid, okay.
And the purchase of the property was to be made within the 2 years of the lease agreement. That never happened. The second contract, which was negotiated in February, requested for the plaintiff to deposit $10,000 as earnest money. That she has not done, and therefore, go ahead. I'm sorry.
Your Honor, that's the exact point I wanted to make to the court. So subsequent to the 2-year term of the lease agreement from January 2020 through January 2022, Ms. Gonzalez had always made timely payments of rent, and like I just mentioned, she paid the $10,000 deposit to the defendant landlord. Now, after the 2-year expiration, when she did exercise her right to purchase the property, a commercial contract was prepared by a third party. It wasn't a third party real estate broker. It was a private lender. The contract was executed by both Ms. Gonzalez and the defendants, and the $10,000 of earnest money alluded to in the second contract was meant to be, or was the same $10,000 that was already paid by Ms. Gonzalez. It wasn't a second $10,000 payment. I want the facts, to be clear, and that's what we intend to establish, at trial. So our position, Judge, we're the plaintiff. Ms. Gonzalez is a plaintiff. She filed the suit in your court to enforce the contract, or in the alternative, seek damages out of what we believe is the defendant's breach of the contract, Your Honor. So in response to the defendant's request for rental payments, I understand the position of the defendants, I do, but Judge, I think it's important for the court to keep in mind, as I alluded to, I think 2 weeks ago, Ms. Gonzalez has, she's made improvements to the property in excess of $20,000. I spoke with her yesterday. She just actually made she has upgraded the air conditioning to a refrigerated unit, and I've asked her to compile, those receipts along with every other receipt that she's made. So at this time, the defendants are asking for $19,000 of back due rent, which I don't think there's a lease agreement to justify that amount of monthly rent. But at minimum, she'd be entitled to an offset, Your Honor. That's our position. We're seeking to enforce a contract to purchase the property. I don't see why possession of the property would be surrendered. There was 2 FED actions filed by the defendants, and both were denied by the Justice Court. And we're here because this is a trespass. This is not a trespass to title per se, but this is a suit to enforce a contract for the purchase of real estate, Your Honor. That's our position at this time.
Your Honor, may I respond?
You may.
The improvements under the first contract, which is the lease agreement, does state that any improvements to be made by the tenant shall be at the tenant's expense. It is a business, so they need to operate their business. So any improvements, it's at their expense. So any offsets is completely irrelevant. The simple fact is they're occupying this property and not paying anything on this property.
Your Honor, may I quickly respond?
Yes.
Ms. Gonzalez would be entitled to an offset for the mere fact that she's trying to enforce the contract to purchase said property. If ultimately this court or a jury denies her request for specific performance, at minimum she'd be entitled to an offset to what she has improved the property by virtue of her thinking all along of the belief that this property was eventually going to be hers, Your Honor.
Okay. So in terms of the injunction, Mr. Lopez, the relief requested is that this is what the court is understanding is, or at least some of the things that are at issue right now. I guess the characterization of that $10,000 deposit and whether it carried over into this second contract with the idea of purchasing the property. Also, the issue of offsets, if there are, I don't know if either of the contracts speak to that directly, but that seems to me to also be an issue. What I'm not understanding is why there are not payments being made by Ms. Gonzalez in the interim. And so I am going to grant defendant's request that Ms. Gonzalez place into the registry of the court. I don't know if is it $1,500 monthly that she is supposed to have been paying, and I'm not speaking to whether or not she would then be entitled to an offset, but in the interim, the court is going to order that she remit those payments into the registry and I guess up to date and going forward. So every month that happen.
Up to date, Your Honor, is 19,500. Is that the amount?
And after that, it's $1,500 a month. Is that right?
Yes, Your Honor.
Mr. Lopez, if you would please prepare the proposed order on that. So if you could include the specificity so that it is clear that the amount and up into today, what is outstanding, and then while the case is pending, I don't know if it relates to a certain due date, things of that nature. I want it to be very clear so Ms. Gonzalez understands how the payments are happening. They will be into the registry of the court. I feel like we need to get this, if you all are asking for a jury trial set fairly quickly, unless there are some, significant discovery issues, I wouldn't imagine, we could probably set it this year. So. And,
Yes,
and I'll also be ordering you all to mediate. Have you at any point, I wouldn't imagine that has been done.
No, Your Honor. Your Honor, just a point of clarification. How soon does Ms. Mary Gonzalez need to deposit the 19,500?
Mr. Saloom, do you have a good handle on your client's financial situation? I don't know. I mean, I'd be happy to give it about 45 days. But if we do 45 days, then that probably is going to mean that we're going to have an additional payment. Yes, sir.
Your Honor, I will say, I don't have, at this time, I don't have a good handle on that yet. I would request, as far as the characterization, I mean, obviously, Your Honor, this is a large amount, a lump sum, and I want to make sure my client is compliant with the court's order. Are these payments going to be characterized as rental or mortgage payments? Because
for my purposes, I'm not characterizing it as anything. What I understand is there's some payment that it's disputed what it was for, but it's basically $1,500 a month for her occupying this space, whether that meant it was in furtherance of the purchase of the property. That is what I think you all are litigating. I also think that is what is still outstanding is the $10,000 deposit and I haven't heard an exact quantity, but whatever a potential offset might be, if that's going to happen, if there is an offset, I don't even know. But in the interim, what we do know is that there are some outstanding payments toward what that is. I'm not really sure, but they are outstanding. And so she's still occupying the property. I don't know if there's the intention is still to try and go forward with some type of purchase. I don't know any of that. What I do know is that there are payments outstanding and they're going to be held in the registry of the court while the case is pending.
Thank you, Your Honor.
Yes, Your Honor. And I do believe this case is ripe for mediation. I'm hopeful, Your Honor.
Okay, so I'm going to order it. That's what we're going to do right now. I don't feel like this is something that is necessarily discovery document intensive. I think you all just need to take a stab at it. So I'm actually going to give her 60 days to get that paid in. I'm also going to give you all 60 days. You have 60 days to go to mediation. If
Yes,
you
yes.
all want to agree on someone, that's great. If not, I'm happy to order a mediator.
Yes, Your Honor. And I would propose to Mr. Lopez, maybe Judge Villa. I've had much success with him, but I mean, I'm willing to work with him on whoever we can agree.
Yeah, that's fine. Judge VNC is bilingual. That may help my clients as well.
Okay, so we're gonna do an order, a mediation, Judge Villa within 60 days. In addition to the order on the payments being made. Let's see, so that, what does that get us to? May, July, August. So the deadline will be August 16th. I'm sorry, August 15th to get that mediated, and we will be back here on August 16th.
Thank you, Your Honor.
Thank you very much.
Thank
Mr.
you.
Lopez, I'll be looking for that order if you want to go ahead and circulate it to Mr. Saloom just for a review and then get it to the court, please.
Thank you, Your Honor. Yes, I
Alrighty.
will.
Okay,
Thank you,
anything
Your Honor.
else?
Thank you.
Not at this time.
Thank you very much.
May I be excused?
Yes, sir.